So, good evening. So, quickly going into the session, I thank Dr. GVK for giving opportunity for this unique session, medico legal issues, what we face. We invest a lot of time and education, establishing the practice, picking up the practice and all that. Now, this is an era of litigation. We have to remember that. How we talk with the patient, how we document, how we preserve the records, how we, plan the treatment for the patient, everything matters. So that's why this session becomes important. So this session is tailor-made for predominantly for diabetologists who take care of OP practice, physicians or diabetologists who take care of OP practice, because inpatient or intensive care medical legal issues are completely different. So this is tailor-made for us. So we have two eminent panelists here, Dr. Prasanna Venkatesh, who is an expert admin, doctor and a hospital admin and an NABH assessor, and we have Ms. Swapna Sundar, a senior legal counsel with extensive experience in handling these issues. So quickly going to the session. So first going to the first most controversial or sensitive thing, generic names. So I am sure there is a notification from the NMC that only 2022 there came a notice that only generic names. Then after a lot of outcry from the medical practitioners, they said you can mention the brand name below which you can mention the generic name, but generic name should be typed, and most of the softwares we have mentioned the generic name, luckily. So I have certain questions to the panelists. So what is the legal standpoint on generic drugs in the prescription? From the hospital admin perspective, how do you see generic drugs?
Sir, basically the Indian Medical Council Act refer 1.5, it clearly says that a physician should only prescribe drugs in the generic name. But practically it is not possible, and many software offer this kind of thing where the brand name is given and then a generic name is printed below, which is practically accepted. But the rule says that the prescription should only be on a generic name.
Okay. So is it mandatory to mention a generic name?
Yes, it is mandatory. Yes, it is mandatory. Yes, it
that
is
means
mandatory.
I cannot write Dolo 650 or Crozin alone. I have to write tablet paracetamol, but any brand I can choose.
Yes, any brand you can choose, but the choice is not ours. So basically we have to only prescribe the generic.
Choice is not ours, which means choice is not of doctor's choice.
Yes, this is not the doctor's choice.
The most sensitive question, can the pharmacy interchange a pharma brand with a generic form? Is it allowed?
So the same molecule the pharmacist can issue, because he is legally bound for any dispensing errors as per the Pharmacy Council Act. But he cannot change the molecule per se without informing the physician.
So he can change the brand without informing the physician. That's a key takeaway.
Yes.
Because we always crib that a particular chain of pharmacy changes our brand. That is legally allowed, unfortunately. So let us not crib about that. So they can change the brand as long as the composition is same.
The same, yes.
Am I right?
He cannot change the rationale of prescription. So the physician has a dosage and the rationality behind prescribing a particular drug. Only the doctor can do. But he can, the pharmacist can issue another brand. He need not inform that to the physician.
What's your take on that, madam?
I think as doctor said, it's quite right. He can change the brand and give. But the patient as a consumer has a right to demand a particular brand. So if you have written Dolo and he says, no, I want only Dolo, then the pharmacist has no right to give another drug. So he can persuade, if he can, the patient saying that Dolo.
And pharmacy says I have 4 brands, he can choose the brand. Am I right?
Absolutely.
So that's a major change, and that's a major change in the law and the way it is practiced, and we should be aware of this. So it's gone out of our hands. That's what I want to say, unfortunately. Okay. So that's one thing. Then there comes a patient who is a long-standing diabetic. There are some skin lesions, pemphigus skin lesions secondary to a gluten reaction, whatever. The physician takes a photo of the skin without written permission from the patient. Is it permissible? But he shares in a WhatsApp group without telling the patient's name or data or anything. Just puts the photo in his own academic group without telling the patient details and share, I saw such a skin lesion today, please don't use, only for educative purpose. What's your view on this?
Sir, basically the consent is mandatory, because the patient should give the consent for the photograph. One, he cannot share. even if you are going to de-identify the patient, the owner of the particular photograph is the patient. So explicit consent needs to be obtained before such photographs are taken, one, and even for sharing. And we should also be aware that the patient can revoke the consent that he gives anytime he wants. He can say, okay, you take a photo, but 2 days later he can come and say, please don't share this, because I don't want it to happen. So that can also happen. So technically you should not share without getting a consent explicitly.
Absolutely. And it is, even if it is for his own good, say the doctor wants to share it for a second opinion with his mentor or with another doctor, even at that point it cannot be done without the consent of the patient.
Okay, there comes the intellectual property right for the patient data. I remember an incident which happened in the ICU. I was walking inside the ICU 4 or 5 years ago, and one attendant was looking at the case sheet of a patient ventilated. He was looking at the case sheet. I said, sir, please don't look at the case sheet. I said, why? He asked me, why? Why, doctor, why I should not? No, that is confidential. Why? This is our property. This is patient's property. I am the attendant. I want this case sheet. I was actually taken back. I didn't know how to answer that. And later I came to know he was a lawyer. Later I got a clarification on this issue. Everything belongs, case records belong to the patient or the family, and the hospital is the custodians. So how do you view that? So,
sir, that is very correct, because the property belongs to the patient. All data classified and which can identify the patient, all data belongs to the patient. And the hospital or the intermediary is only a custodian. This is also told right now in the Data Protection Act that any hospital or intermediary that uses these data are only custodian, and without the permission of that particular patient, you cannot share or retrieve the data. He has to give a consent in every step of retrieving the data. Now that has become a mandatory rule.
And because you have mentioned intellectual property right, even if it is an interesting case and you want to write about it or talk about it in a lecture or conference, it cannot be done without the consent
permission of the patient.
Doctor, yes, sir.
That's why we have a form when our patients get admitted into the ICU or into the emergency department. We have a standard form that your data may be de-identified and may be used for research purposes, for data collection, for data analysis. Are you okay with that? And most of the patients sign. Almost 100% of our patients say okay, nobody objects. But if when the patients are getting more aware now, if they object, you cannot put them into a data analysis. That's most, because in Western countries it's a standard thing. Many patients refuse. No, you cannot use my data, even my data for research. If they say that, you cannot use, because data belongs to the patient. That's the point.
Including the marketing right now that is happening, like patient gives testimonial, even those come under this, because they may claim that they have been treated for a cause, but is it a real cause, and the consent, is it properly obtained? Because they can also sue the hospital or the practitioner who's actually publishing that.
Absolutely. Yeah. So even when they speak about their voice, their manner of speech, whatever they are speaking in the testimonial, they are giving it for a particular purpose. They may say it is okay if you play it on the video in the hospital, but not on your website. So the consent is also given for a certain purpose, and you cannot extend the purpose after the consent has been given.
Again, I recall another incident which happened 3 months before. A patient admitted in ICU. Somebody, a known friend of mine, called me and said, such and such patient is admitted in the ICU. The patient is my neighbor. What is happening to the patient? So just innocently I shared the data. Dr. Padma knows. So they had a tough time as an admin. Yes. So in spite of having a long experience in ICU, I made a grave mistake of telling about the patient information to that neighbor unknowingly. Just like that I told, no, the patient is getting better, don't worry. Something like that. So we often get calls, right? Somebody calls and says, sir, such patient is admitted under your hospital. Please ask and tell. And the family made a big fuss, lot of trouble, and they have to apologize. I have to apologize to them. So thank God. So never do that. Somebody calls you and asks, how is the condition of the patient? Be careful. Make sure they are the one who have signed, because the patients are getting more and more aware of these issues.
True. In fact, one of the issues that we also face is that an elderly patient is being treated, and maybe one son is taking care of the patient here, one son is in America. So the America son calls and asks what is happening, you cannot share.
But that
have
comes,
to be very
I think,
careful.
most of the time, because most of the people are there, they want to have a video call with the patient.
Yes. We have to be very,
Very
careful.
careful
So
to-
identifying who the person is to whom we are sharing that data.
Okay. So we go to the next issue. A young female, poorly controlled, brittle type 1 diabetes. Doctor gives, in private practice, doctor gives free insulin for the patient usage, and he also arranges free continuous glucose monitoring for trial use. Patient finds that insulin is beyond its expiry date and there are sediments. Unfortunately, the CGM device malfunctions, some mistake, patient lands up with decay in the hospital and they go to sue the doctor. How the court views a malpractice suit filed after a free prescription or free medicines, and of course there is a third party involvement here. The company has given the CGM device. How do you view that?
So I'll take this. So whether it is paid service or free service, even if it is a free camp service, if treatment is provided, the doctor is liable, and whichever doctor or hospital that is conducting the camp will be liable. If the gadget is being provided by a third party vendor, it is still the job of the institution or doctor who is dispensing that device and drug to be responsible for the outcome. There is an issue here. The court will look at third party liability and product liability, but still it is up to us to take care of what devices or medicines we are dispensing.
I just want to add one point in the scenario that you had presented. The doctor actually gave something without seeing at what he's prescribing, even if it is for free. There is a landmark judgment, VP Shanta versus Union of India, which clearly states that any free prescription, including treatment in the government, is actually comes under the Consumer Protection Act. But here, our ethics and etiquettes very clearly states that we have to first do no harm. So when, as a doctor, I'm going to give something for free for the benefit of the patient, it is my responsibility to check whether it is, not expired or something. That is the first thing I would see as a very good citizen. But the court, as Madam said, may also view at the third party liability as well.
We will look at it, the court will look at it, but it will hold the person who is dispensing to be primarily liable.
So first do no harm, I think, should be the take home message here, because even if we are doing it for free, it should not harm the other person.
That's why most of the hospitals with the NABH or JCA accreditation, NABH for Indian standardization, JCA is for American standards, we know that. So most of the hospitals with that accreditation never allow free medicines inside. That will be a hospital policy. You may wonder why. There may be a business interest, again it's because of this. You cannot allow a gadget or a medicine or anything which is not being tested or standardized or been tested to be accurate. Just like you cannot bring a gadget into, let it be a glucometer, let it be a ventilator, there will be medical legal issues if something happens. That's why NABH or JCA, they don't permit outside medicines or outside gadgets into the hospital. So let us be clear with that.
I think even the OP nowadays can have an NABH accreditation.
Yes, all the
for
more.
standardization. And Ayushman Bharat also has come up. The others that we are going to talk, like the CEA and all, they are all come to standardize the quality of care. So either OP or IP. So the quality of care and standardization is something that everybody are looking at.
So I can recall an incident where a senior ENT surgeon operated on a doctor for a base of skull tumor and he didn't charge. He didn't charge, saying, you are a doctor, I don't want to charge. Something happened, thrombosis over the jugular veins. They filed a malpractice suit saying, what is mentioned in the, the document, you gave free treatment, that is why you didn't care properly. That is a claim given by a doctor against another doctor. So this was a sensational case in the hospital in which I worked a decade before. Okay, right. Then, what is Clinical Establishment Act? Is it relevant now after NMC, after all this, after newer regulation? Because it lost its popularity post-COVID. Post-COVID, lot of clinics mushroomed and there was no monitoring. Do you think it's still relevant?
Sir, it is very valid even now. See, any establishment, a commercial establishment has a lot of licenses. Let's say a shop has a commercial license or something for a shop. But as a clinical establishment, we have none of these licenses. I'm talking about the OP part, where we are just having a OP and we don't have any establishment. This comes very handy for us to go for the other, registrations or something. But the main aspect of bringing in a CEA by the central government was to standardize the quality of care. So under which other states have either adopted it or they have their own. Like Tamil Nadu, we have our own TNCEA. But the rules and regulations are the same. It is mandatory for any it includes all the allopathy, Ayush, any practitioner, they have to actually register themselves here. These are mainly for standardization and for data collection from the government side as well.
Okay. So how I view as, I mean, as just a doctor, I have a OP clinic. When I am not registered with the CEA, nobody is going to ask me immediately. But when I land up in court for some litigation or something, that's when this becomes a problem. It is like driving a two-wheeler without license. With the if you have a helmet, the police is not going to stop you. You will be driving. One day, when you are caught with some problem, then that's how I look at it.
That is very true, sir. But there's another thing. If you have a competitor doctor who wants to actually bring down your practice and you don't have a CEA, he can write to the joint director.
That happens.
So he
that
can
happens
actually
every time.
Yeah. I know we are all humans, no, sir. I think everybody acts in the same way, even if you are doctors or not. So I think that is a very valid point. I mean, very easy for him or her to actually send a notice against you, and the joint director or whoever comes in your jurisdiction, they can come and seal your place and go.
One of the important changes that is happening in legal regulations is that people are, the authorities are expecting people to be self-compliant or self-certified. So as you point out, when there is an issue, then the question becomes, are you compliant or not? Until then, as long as you are self-compliant or self-certified, it's fine.
Yeah. So another, trending or I would say sensitive issue. So what qualifications can be mentioned in the clinic boards and prescription pads? There are a lot of overseas qualifications, including American board, MRCP, and there are a lot of problems with MRCP. If you do MRCP in UK, that can be registered. If you do anything outside UK, you cannot register. American board, there are a lot of regulations. EDIC is the most highest qualification in critical care when it comes to global. Next to FCCM, that is the highest European degree, but that cannot be registered in the NMC, unfortunately. So there are, even you may think you have an European degree or American degree, that may not be registrable with an NMC. How do you view that from hospital point of view and legal point of view?
Sir, as you rightly said, there are a list of degrees that can be registered with the medical council. That is available in the public domain. So all those things can be registered and can be. So the rule clearly states that whatever is recognized by the medical council, you have to display it on your place of practice and also display the same in your prescription and your seal or signature, whatever. But those are not recognized. I don't think we can actually put it on the.
We cannot. And if it is okay as marketing literature or brochure, if you want to put some extra qualifications within courts if you want, but court will only look at whether you are primarily qualified to practice as per Indian law.
Indian law.
And that is mandatory.
So can I, for example, I can put only the registrable qualification in the board.
Correct.
But I print a brochure for my patients or a diet chart, for example. So I can put my extra qualification. Is it a problem?
If it is marketing, yes, you can. For instance, you may have some nutritional or yoga qualification in addition. If you are a lifestyle coach, then you can put that in addition. But you must make it clear that it's not a medical qualification. It should not be along with your MBBS or other qualification that you are posting. It should be clear that I have some additional qualifications or trainings.
The rule also, including the medical council, is very clear that everybody are called as a registered medical practitioner. Yes. They don't say physician, surgeon, super specialist. Everybody are treated at par. If I am not wrong, I think Madam can clarify on.
In law, it is registered medical practitioner as per the registration qualification and registration in the state medical register.
So I see a discrepancy between NMC and national board. NMC will say you cannot register overseas qualification, but national board allows those degrees, people with those degrees to practice as teachers in established institutions. So I don't know, two government bodies contradicting each other. So these are all, I don't know whether once we stand in front of the court, I don't know how.
So in front of the court, mostly the case is relating to therapy or treatment or practice. The school and college and education and training will come under a different qualification in law.
Oh, let me be frank, madam. An MD physician treats a cardiology case. I mean, a cardiology case. He is quite an expert in treating that. 25 years he has been admitting heart patients and treating. One fine morning something happens, the patient dies, comes to you. Are you going to be very strict? You don't have a DM, or how are you going to take it? Are you going to consider his experience, his track record? There are so many things, right? There are many of us are qualified to treat.
A typical lawyer answer will be it's an arguable case.
Oh my God.
but best thing is that court will not look at experience and other things. They will first look at the primary qualification and whether they are practicing and their experience is in the relevant field of qualification.
Quite scary.
Can I just add one point, sir? I think the court will also see if you are in a rural area practicing and there is a very minimal thing that there is accessibility to healthcare is very poor, and that particular physician is able to treat that for MI. I think that they can accept.
They will.
But now we being in a city like tier 1, tier 2 and all, and where all the specialists are available, and yet I or the person that you are going to, we are talking about, says that he is not a person that he is qualified to be, then that is...
Yes, I agree. Emergency treatment, trauma care, any particular accident or any place like a very rural area, remote area, then we expect doctors to know at least that much to stabilize the person.
Yes.
Yes.
For stabilization purpose, even a post MBBS definitely can give, for example, antiplatelets, primary treatment.
Yes.
So if something happens during that time, I think they should not be blamed. That's the right way of approaching.
I think even this 48-hour treatment that the government has brought is something to do with that.
48 hours?
Good Samaritan.
Yeah,
Yes.
Good Samaritan Act rule. No, within 48 hours, anybody with a trauma, they can take to the nearest hospital, any hospital, and the government will bear the cost. Is one of that has come with the I'm sorry, yeah. Sorry, thank you.
So another 2-3 slides. Is that okay? Another just 2-3 slides. Last 3-4 issues. So another thing, most misused or kind of, I would say, sensitive, again, all of us use telephonic consult, WhatsApp consults, email consults. One of the lawyer we had a full day medico legal conference in Vijaya. One of the lawyer told a very interesting point. You are walking with your friend. Your friend is a non-medico or medico or whoever it is. You are casually talking and walking along with them in the beach. You are talking general issue. Suddenly he asks you a question. Hey Balaji, my sugar is 200. What should I do? The moment he asks this question, the friendship ends. The doctor-patient relationship starts. So how many of us are aware of that? You may tell, okay, you take insulin, you take tablet. You can tell anything. Or you may say yoga therapy, whatever. But the moment you start answering that question, the friendship ends, doctor-patient relationship starts. In this context, people keep sending WhatsApp message, emails, all this. So how do you view that?
Sir, this became very famous during the COVID time when the access to healthcare was very limited. So the government themselves came up with a guideline as to how the teleconsultation should be. It was, I'm not sure, please correct me if I'm wrong, it wasn't updated after 2020. Yeah. So that was the last update. But the guidelines, I think, still holds good right now because this technology has improved and everybody has access to phones. So it is very clear what we are going to do in a physical consultation with the patient should be followed in a teleconsultation. There is no change in that. Now, they have also given guidelines as to if it is going to be a new treatment you're going to start or a follow-up. That has also been defined. And what drugs can you prescribe? Let's say there are 3 modes of communication: audio, video, and the text. So, in these 3 kinds of communication, what are the drugs that you can give and prescribe? So, it is list A, B, and O. And prohibited drugs, I don't think you can give. So they are very clearly defined. It's an extensive, but I think it's very easily understandable.
So you cannot prescribe Zolfresh for 30 days?
No, you cannot. I would like to quote one incident. The Sushant Singh Rajput, an actor who passed away recently, his partner had actually sued the doctor who had prescribed him these
sleeping pills.
Yeah, sleeping pills through telemedicine. So that was one of the things that was really brought, and there was one issue in last October in Tirunelveli where the doctor was present in another clinic, and there was a staff nurse not trained or not very qualified in his other clinic. He was giving instructions through video call. Now the joint director of that particular area, they came and they sealed the place because there was no qualified person actually delivering the treatment. It was only, you can ask the other person to give an injection also, but there should be a medical practitioner there when the injection is being given.
So it should be done through a registered platform.
Yes.
There is no such thing in the guideline. In fact, the guideline doesn't specify that it should be a platform. It can be WhatsApp, it can be email. Right now there is no such rule. But what I think doctor is saying is that the person who is giving the instructions on the platform or on WhatsApp or whatever should be the medical practitioner. He should not be the assistant of the medical practitioner.
Yes, that is one. And one thing that is very mandatory is identification of both the parties.
Yes, absolutely.
Now, let's say I am a doctor, I am treating one of my patients through teleconsultation. Identification should be, so I should identify that this is the patient that I am going to treat, and he should also know that I am the doctor, where I will be displaying my qualifications. So a platform will work better, because in WhatsApp I will not be able to do all these things, and these should be auditable data. So let's say I need a data that I need to audit in case of any litigation. A platform will provide better data rather
So I
than
give a scenario. I am outside my clinic. Suddenly one known patient comes to my clinic. I tell the nurse that give injection neurobion. Okay, and she gives, because she has always been giving. Nurses are qualified to give injections. They are trained and qualified. So I give a prescription like injection neurobion, or let it be an antibiotic. Suddenly the patient has anaphylaxis, syncope, falls down, dies. What is wrong in that? The nurse has been already been giving. I prescribe the medicine after thorough medical examination.
This is not telemedicine per se, but I will come back to the first one.
I give a telephonic consult.
Yeah.
It is
Basically,
still
I talk with the patient telephonically. I give telephonic orders to the nurse.
The same, sir. Deepa Sanjeev Puraskar versus state of Maharashtra. Same thing happened. I just had a note. In Maharashtra, where the delivery was conducted, and the doctor had given all instructions on phone without examining the patient. Now the patient had landed up again in the emergency with bloating sensation and bleeding. And yet the gynecologist never came and examined the patient, and it was taken very seriously. Now, as I initially mentioned, the rationale for prescribing a drug should be there. The doctor must examine, make a diagnosis, and only give a treatment. Anybody can call and ask for a neurobion injection, but what the rationale of me prescribing a neurobion injection other than, it's just a B12 injection or something like that. So that rationale should be there, and the proper documentation. And though the nurse is qualified, I think the doctor has even more liability and responsibility.
Absolutely. In the situation, if it goes wrong, court will definitely say that the medical practitioner should have been on the spot. So even earlier we discussed this remote teleconsult case. Let there be a remote village where a person is being given a consultation by an expert. The expert can be in Chennai, but there at that end there should be a trained, qualified person. So
preferably a doctor should be there.
Definitely.
Correct.
Yes.
Though midwifery deliveries are allowed by Government of India, in this case probably what happened is gynecologist didn't even see once.
Yes.
So that's a mistake.
After the delivery. It was only a telephonic call.
Yeah, that's a mistake. So though delivery by nurses are actually happening throughout the country.
Sir, but even in that case, this
Even
accessibility
many
is not a problem.
Small taluk level hospitals, I think nurses conduct.
But a duty officer will be there, sir. Even if a midwife is going, rationale should be there, and the proper documentation. And though the nurse is qualified, I think the doctor has even more liability and responsibility.
Absolutely. In the situation, if it goes wrong, court will definitely say that the medical practitioner should have been on the spot. So even earlier we discussed this remote teleconsult case. Let there be a remote village where a person is being given a consultation by an expert. The expert can be in Chennai, but there at that end there should be a trained, qualified person. So
preferably a doctor should be there.
Definitely.
Correct.
Yes.
Though midwifery deliveries are allowed by Government of India, in this case probably what happened is gynecologist didn't even see once.
Yes.
So that's a mistake.
After the delivery. It was only a telephonic call.
Yeah, that's a mistake. So though delivery by nurses are actually happening throughout the country.
Sir, but even in that case, this
Even
accessibility
many
is not a problem.
Small taluk level hospitals, I think nurses conduct.
But a duty officer will be there, sir. Even if a midwife is going to be particular that any consultant we are either recruiting or as a visiting consultant must have a professional indemnity. This has been seen as a mandatory document that we require. This is from the practicing side. But the indemnity for OP is still valid. Everybody are taking OP. The only thing is that you have to tell your place of practice, declare it to the insurance company and get it printed on your
place of practice.
Place of practice.
Oh, if I practice outside this place, it is not valid.
No, it is not valid. It is not valid, but yes.
Well, I thought only outpatient. It's new that I have to mention my clinic
Yes,
address
you have
also.
to, sir. Your address, your place of practice, where they will ask your TNCA license to prove that you are practicing there.
Policy has to contain all the details.
Yeah.
of the-
And if you are, let's say you're going for 10 places, all the 10 places must be enlisted. And I found one or two consultants who have gotten the professional indemnity as practicing pan India. I don't know the validity, but I have seen, but it is very specifically mentioned by the government side, the insurance that are government owned, that say you please mention your places of practice, not place of practice.
A doctor comes to you with the criminal negligence,
Yes,
complaint
Yes.
from the patient side.
yes.
He ignored the care post-operatively. A hot water bottle was kept between the back, burns. It's a negligence case. How do you view? Do you even allow? I mean,
Will indemnity
does
cover?
indemnity insurance change that in any way, or will it apply? Or
It will apply. In fact, indemnity insurance applies in 3 cases. One, it will help them to deal with the legal costs and whatever other costs are there. It will help them to pay the damages that they have to pay to the patient. And third is for any other attendant aspects like change of business or maybe for some months they are out of a job or something. All 3 are covered by indemnity insurance.
okay, right. What is your view on that?
This, I think, Madam has spoken. I just want one disclaimer that what to look at the small print is
Yes.
very important.
Absolutely.
So, for what insurance we are applying for, I think the small print from your insurance broker or your agent, you need to get the clarity as to why you are getting this insurance indemnity. Properly certified with the places of practice is what from the doctor's side I would like to say, because Madam has touched
Yeah.
on the legal aspects.
There are, so I looked at a few indemnity insurances that I provided, ICICI Lombard and Reliance and so on. The small print is very important because some policies clearly say we will not cover cosmetic surgery, we will not cover plastic surgery, we will not cover criminal acts. Now, after BNS, where Rash and Negligent Act specifically mentions doctors, then does that cover negligence or not? So,
That means if I swap the kidneys for a renal transplant, criminal, what is that called?
Rash and Negligent Act. What?
No. If I do a unauthorized renal transplant, it won't be covered by your indemnity.
Yes, it will not be covered.
It won't cover
So
negligence.
that
right.
depends on the policy. That
Policy.
you have.
So there are
Yeah.
differences. Okay,
Yes.
right.
Policies are different,
Okay.
and small print is important.
So as Madam rightly said,
Great, sir. Right.
as Madam rightly
Actually,
said,
the cost will be very less for
Yeah, very less.
indemnity. 2,000 rupees per year, 3,000 rupees, not more than that, less. If I'm 10,000. So I have only for ICU. I don't have OP for OP.
So actually, group practice they are taking. There is indemnity for group practice
Yes,
as well.
that's a good idea.
Yeah.
Okay. So Bharatiya Nyaya Sanhita came maybe 2-3 years before, and there was an outcry among doctors, and IMA was protesting because straight away 5 years imprisonment for criminal negligence, 2 years for doctors straight away, because the punishment was increased, the duration was increased. But do you think it is really draconian, or do you think okay, or should I be scared about that, or?
Well, the real issue in BNS, because we also filed an implead petition here on behalf of some doctors, the issue here is that earlier the word medical practitioner was not there in BNS, and that meant that people did not readily think of taking a doctor to police station or filing a private complaint against them. By including these words that medical practitioners are liable under Rash and Negligent Act, it actually makes them vulnerable, because patients or whoever is upset with the medical practitioner immediately thinks of going for BNS. The second important thing, which may be a bit of legal aspect here, in other countries, rash, negligent, gross negligence, malpractice, all these things have become defined by law. In India, rash and negligent is still considered as one box, and that is a little bit of a problem. See, a doctor may be negligent by inaction, a doctor may be negligent in acting, a person who is taking care, like we earlier discussed, in trauma and so on, in spite of best efforts, life may be lost. In such cases, they will have to suffer until the magistrate acquits them. So eventually they will get acquitted if they've done the right thing.
But the process, as Madam says, is a very long process. Yes. So, the rather than you being acquitted, I think the mental trauma and the thing that we need to go through as a professional will be more. But our doctors more vulnerable. I think doctors are still vulnerable only, even with BNS or with, because we are dealing with the patient. Let's say there is a hierarchy. That end user doesn't go and talk to someone directly. Here we are dealing with them. So, and there was one thing that a lot of this Hospital Protection Act wasn't actually properly utilized, and there are very less number of cases actually filed. Okay. The other side, yeah.
Okay. So, how many of you have a lawyer for yourself, a family lawyer or anybody? We have family doctors. We ourselves becoming doctors, we may not have family doctors, but we have tailors, we have hairdressers for us. We buy in a particular provision shop. We have our own family, shops or service providers. So, how many of you have lawyers for the clinics? I think it's a time to have. Great, sir. Nice. So, we should have lawyers, and we should have lawyers to at least make a call and say, there are 10 people standing outside my clinic or hospital. They are barging inside. No, what should I do? So, that's kind of, shift in the attitude should be there.
Absolutely. I think it's a part of hospital administration as well as personal practice that doctors have, that they should be aware that these risks are there. So, how to mitigate them at the first level?
Okay. So, this is the last question.
Told to them, what is told immediately in the wake of any problem, told to them is taken over, and from there it starts. So, unless you ask the lawyer and tell them what is to be really told to them, we are not, because 10 people gang on us, they ask for the, they want to see that certain things are not given to them. They take a photo, it can become incriminating.
Yes, yes.
So, unless you have a real, the thing is going to become difficult.
Yes. Sir, but this problem will be there everywhere, sir. They will definitely try to bully. The problem what Madam is trying to say, you should have a robust system in-house that will try to protect you rather than...
Violence against doctors is a separate issue. That is separate. We had a separate session on that.
What can be told to them is the thing which, if you concern...
You are saying told to the patient? Yes. Yes. Yes.
In a death, what is to be told to them, how to deal or what needs to be done.
Yes.
We are something a lawyer would be able to decide better. So
yes.
Yes.
Yes. Absolutely.
So, how many of you have a board outside your clinic mentioning scope of services? Okay. Hospitals have scope of services. Any hospital, we provide OT, neurosurgery, cardiology, burns, and some hospitals say we don't have cath lab, we don't have pregnancy gynec services like that. Okay, because that's a legal requirement, because suddenly a pregnant patient is wheeled inside a hospital which doesn't have a obstetric service, it will be a nightmare. And when you don't put a board and they go for litigation, that becomes a problem. Like that for OP also, we should clearly tell what we are capable of doing as a diabetologist or a physician. This is what I can do, this is I cannot do. Maybe you cannot put a board, I cannot do this, but definitely you should mention what you are capable of doing. In this context, certificates become very important. We keep giving certificates to all kinds of patients for all reasons. We may treat for different reasons, and they may have a stroke, we may give a certificate, they may have an MI, all this becomes an issue. So, how do you view that while giving a certificate?
So the certification, this was a always debated topic, and recently the Medical Council has issued a guidelines as to how a practitioner should issue a certificate. Now they say that you should always issue certificates as spells. The first spell for a minor ailment can be only for a maximum of 5 days, and then based on your professional thing, you can extend it by multiples of 5. If it is going to be a fracture or an MI that requires prolonged stay, you can give a maximum of up to 6 weeks. This is defined by the guidelines that are given by this one. But it is always safer to really examine the patient, make a documentation of what all symptoms, signs they have, and give a genuine medical certificate will never cause a problem. There is also one more thing, you have to maintain these records in duplicate for 5 years.
5 years.
5 years is mandated.
Certificates for 5 years.
OP records need to be maintained for 3 years because we are the custodian of the particular OP record. Right now, when it becomes digital, it is not going to be a problem. But medical certificates in duplicate need to be maintained for 5 years. That is by law. This is also defined by the Medical Council, also by the TNCA. So both of them say the same thing. 5 years you have to maintain the certificate, because there was one incident where I think we have spoken. There was one boy who was bought by his father claiming that he didn't go to another practitioner, that he didn't go to school for 2 days, can issue a certificate. This doctor gave a certificate. But then a police comes and says that, sir, he's been remanded in a juvenile case, and for 2 days we have been trying to catch him, and now he's producing a certificate given by you, telling that he's not well. So please refrain. So there was nothing taken against the doctor, but issuing a genuine certificate is better rather than giving such certificates and getting ourselves in trouble.
Yes. No, I completely concur. Court will definitely look at whether the person was examined by the doctor and whether the certificate given was a genuine one.
This also applies for the labor things, like
yes.
the employee or the labor law also
yes.
says that if on medical grounds you have to terminate somebody
Correct.
or something like that also.
Correct. Many areas we now require medical certificates like migration, visa, travel and so on. In all of these cases, the court will definitely look at whether you saw the patient or not.
Okay. Any questions or anything? So
I'm the hospital owner. When a surgeon admits a case, all the hospital facility being used, but the doctor brings drugs from his clinic to the patient. I do not from my farm. It happened to me.
ஆக்சுவலாக நடக்கக்கூடாது. ஏன்னா if you are the ஸ்டாண்டர்டைசேஷன் சொன்னதுக்கு அதான் ரீசன். இப்போ சாரும் அதே தான் சொன்னார். இப்போ நீங்கள் ஃப்ரீ ட்ரக்ஸை நான் உள்ளே அலோவ் பண்ணாத ஒரு இடத்துல வேற ஒருத்தர் ஒரு ஸ்பியூரியஸ் ட்ரக் எடுத்துகிட்டு ஒரு ரியாக்ஷன் ஆச்சுன்னா லயபிலிட்டி ஹாஸ்பிட்டலுக்குனா 70%.
I will add one more thing, sir. There is a conflict of interest. Doctors should not, they can only prescribe drugs, am I right?
Yes, sir, yes.
The drugs have to be procured from a pharmacy, from a regulated pharmacy. A doctor can give some, I think they have a...
up to 50,000 rupees or something you can have.
Something they can give, but then beyond that it's a conflict of interest. They cannot be selling drugs.
But you should...
Yes.
One is when prostheses are involved.
Yes, sir.
They themselves generally the orthopedician gets them.
Can be, sir. Yes.
The second problem is when for cancer drugs are involved.
Yes.
They generally it's not available, so they bring.
Yes, there are several
Sir,
drugs which are not available generally in the pharmacy, but for that even the doctor has to be licensed to give those drugs.
Yeah, can I just add one point, sir? These will come as a, what do I say, the hospital has to have policies as to how they are going to procure such drugs.
Yes.
Like these are all bulk purchases and they will be maintained as a stock by the stockist inside the, so the liability is totally his even if there is going to be a fire or something. So these things are, you have to regulate as per your hospital policy as to how you are going to bill it, how you are going to buy. Is the vendor actually approved by your committee or board? These things should be there and nobody can just, walk in with a thing and just implant it on someone because that is breach of privacy of that particular patient.
Yes,
or he should know what is being put inside his body. Without proper approval mechanisms, if I say now I am going to have an implant, what implant? Will you know as a hospital owner, will you know or the surgeon will know? So surgeon should have some process that you are going to approve that this set of products are approved and can be procured or brought inside. You should maintain a data of what is being billed and given.
Yes,
So, yeah.
absolutely.
Question may not be relevant to this topic. We are having software, OP software, IT software, hospital management software. Is it possible for the provider, software provider to sell the data to somebody?
no, actually they sign
NDA.
during a contract they sign a NDA, non-disclosure agreement.
Yes.
I can even mention the names, though we don't support anybody. For example, HealthPlix.
Yes.
NDA disclosure signature has been done both by you as well as by the provider.
But nobody knows. We
don't know, but that should not be done.
Sir, now this Ayushman Bharat Health Mission, that has a digital regulations that have been
Privacy Act,
yes,
yes.
Privacy Act and Ayushman Bharat. These two have robust systems implemented in them where I as a physician or you and me, if I am getting a patient, let's say we are using their database, without his OTP authorization, I will not be able to access his data. So it is very, very streamlined. I think by this year and they will roll out to all the hospitals also, I am not sure. And this ABDM certified portals or softwares are there where it is being certified by them like HIPAA compliant.
Yes.
In the US. Now we have this ABDM certification for all software. So if you are going to go for a software, I would suggest you go for such like ISO and ABDM certified, and now they are also integrating it with the insurance portal, NHCH portal. So all these validations and if they are there, they will not sell your data.
Yes.
they will not sell. Because
I-
earlier it was, sorry, I'll,
No, please, please,
sorry.
sir.
It was, the server was inside your computer. So
that's what I was saying.
now it is cloud based. Now it is
Cloud.
totally different.
Cloud.
So this your software company closes, he will sell the data. He can technically sell. But now it is not like
Pay
that.
for the cloud.
Yes.
He has additional charges for the cloud storage. And he says his data
But
is
his
private.
liability is more because if his data is going to leak, you can sue him.
Yes,
The patient can sue him. That you have leaked my data.
Sir, can a quick comment be made on the indemnity policies given by the IMA and all? That will
Sir, IMA does have indemnity policy, I'm sure, because we are all members of IMA. IMA does give, I think once you are a member, I think up to 20 lakh cover is being given as default for every member. I think you just need to enroll yourself in that PPLS scheme, only that. Sir, that is depending on the policy, the small
How
print,
much?
no?
20 lakhs, sir.
20 lakhs.
20 lakhs for May.
20 lakhs for individual, 50 lakhs for 50 bedded hospital. Anything above that will be.
What sir is asking, should I have extra insurance or will it be valid?
No, 20 lakhs, looking at the amount of the thing is generally being given. It looks very, if you are doing any surgical or other procedure, you are only having OP practice, maybe 20 lakhs would be enough.
Yeah. The scope of service depends upon the scope of service, what you do.
Absolutely.
For ICU, I have 1 crore for me, 1 crore.
More
Because
risk,
if they want to
more-
sue me,
more
they will
insurance.
ask minimum 1 crore. Beyond 1 crore, I have to pay from my pocket. Until 1 crore, I have
advantage
cover.
of PPLSS is they have their own lawyer. So they will fight for us. Here, you have any indemnity, you should have your own lawyer and fight for it. For that, you have to pay separately. That is why 2,000, 3,000 they are charging, 9,000 they are charging.
There is one more thing I need to add, sir. Even in a private professional indemnity what you are taking, if there is a litigation against you, you will still have to inform that particular company. They will have a panel of lawyers who will examine whether this is a really litigation that can take it, they can take it forward or something, and then they will say, yes, you can go, you do it, then we will pay the charge. So even there, so even there it's like a third party insurance where you have to tell that I have a litigation. Then what will happen? If it is nothing, no problem, but then they will hike your premium the next time
See,
you
how
go to.
we claim for a insurance for an inpatient. Similar process. The patient is admitted with typhoid fever, hypotension. We give fluids, antibiotics. We send the treatment record to fax the papers to the insurance company. The ultimate purpose of the insurance doctor sitting there is to reject. He wants to reject. He will find loopholes to reject. He will say, this is not clear, that is not clear, give a letter. Like that, for us also, once our case goes to them, they will try to see if they can reject by quoting criminal negligence. If you do a negligence, your insurance may be rejected. As madam mentioned, you have to see the fine print. If your fine print mentions, if you do a negligence, it may be rejected by your company, insurance company. So be careful of this fine print.
So I think we can close.